Imagine a single unsigned order from the Supreme Court, no full briefing, no oral argument that suddenly lets a federal agency restart enforcement of a policy nationwide. Overnight, people lose protections, businesses change practices, and lower courts scramble. What just happened, and who actually decides? Stick with me, because by the end of this video, you'll understand how the shadow docket quietly rewires power in Washington, step by step. Hi, I'm host Name with Shadow Docket Courtroom Files. Today we're unpacking the Supreme Court's shadow docket, what it is, how emergency stays and applications work in practice, why 2025 looked different, and what lower courts and Congress can and can't do when the High Court acts quickly. Quick note, this is educational only, not legal advice. If you need case-specific guidance, consult a licensed attorney. The term shadow docket refers to the Supreme Court's emergency and non-merits orders like stays, injunctions pending appeal, administrative stays, GVRs, and other short-form rulings issued without full briefing or oral argument. Historically, this was a narrow tool for true emergencies, last-minute execution stays, or sudden injunctions that would cause chaos if not paused. But over the last decade, this docket got busier. Use skyrocketed in the early 20s, and accelerated again into 2024 and 2025, reporters and trackers noted dozens of high-impact emergency orders that changed how federal agencies operated, sometimes nationwide, without a full merits decision. Why does that matter? Because these short orders can have the practical force of a major ruling, even if they're not full-on precedent. That means policy can change faster than Congress moves, and often with very little explanation. Would you want a court to make a nationwide policy decision in a matter of days? Hold that thought. Here's how an emergency application typically runs. Suppose a party loses in a federal district court and asks for an immediate pause while they appeal. The losing party files an application for a stay or an injunction pending appeal at the Supreme Court. In recent years, it was often the federal government, the Department of Justice, filing on behalf of an agency, though states and private parties also appear. The filing asks for immediate relief to preserve the status quo, usually citing irreparable harm, the classic legal hook that says, if you don't act now, things will be irreparably harmed. The court usually asks for a response from the opposing party on an extremely tight timeline, sometimes within days or even 48 hours. The court then issues a short-form order, grant, deny, or partially grant, often without a full signed majority opinion. Sometimes there's a brief explanation, often there's none. The relief takes effect immediately when the order is released, which is what makes this so powerful. Notice the speed. The whole process can be compressed into a single frantic week. For agencies and people affected, that's a blindingly fast change. The court is supposed to apply certain legal standards when deciding whether to stay a lower court ruling. You may have heard of Nken v. Holde. Nken sets out 4 factors: likelihood of success on the merits, irreparable harm absent a stay, balance of equities, and the public interest. Those are the guardrails. But critics and some dissents say the court hasn't consistently applied those factors on the shadow docket. In practice, many emergency orders are terse or unsigned, with little explanation of which factors weighed most heavily. That makes it hard for lower courts to know how to apply the ruling or for agencies to plan. Numbers matter. Analyses of recent terms found that the court granted a higher share of substantive emergency applications than historical rates, and that many grants produced conservative outcomes in those snapshots. That raised eyebrows because the pattern looked political to many observers. But a caveat: exact percentages vary by dataset and time frame. Trackers like SCOTUS Blog and the Brennan Center provide invaluable snapshots. But keep in mind, their windows differ, and exact counts should be checked against the court's official docket if you need precise numbers. If a court skips transparent reasoning, how can agencies or citizens rely on the law? That's a central complaint, and it ties directly into how the shadow docket rewires power. Who files emergency applications? Short answer: whoever needs an immediate fix. During the January 2025 through early January 2026 stretch, the executive branch was a frequent user. The Department of Justice filed many emergency applications on behalf of federal agencies. States also appear regularly, both to block and to preserve rules, and private parties and trade groups show up in high-stakes regulatory fights. The identity of the filer often tracks the policy stakes. If the federal government files, the relief sought will affect nationwide agency enforcement, not just one company in one state. What happens to ordinary people? Imagine your job depends on a regulatory rule that gets paused by an emergency order. You might find out from a headline, not a court opinion. Now, let's walk through a composite timeline based on real patterns from January 2025 cases, a typical emergency order playbook. Day 0. A district court issues a nationwide injunction or vacates an agency rule. Day 1 through 7, the agency, through DOJ, files an emergency application at the Supreme Court asking to stay the district court's order while the appeal proceeds, arguing irreparable harm, nationwide chaos, and the need to preserve uniform federal policy. Day 2 through 10, opposing parties get rush deadlines to respond, sometimes 48 hours. The court may also solicit the Solicitor General's input. Day 7 through 21, the Supreme Court issues a short order granting a stay, denying it, or partially granting relief. Orders are frequently terse. Occasionally there's a one-justice dissent. The order's effect is immediate. If the court grants a stay, the agency can resume nationwide enforcement that same day. That can instantly change compliance obligations for institutions, businesses, and individuals. In multiple matters during 2025, the court issued emergency relief that allowed agencies to continue enforcing rules while merits litigation proceeded. Even though a court's emergency order may be temporary, its practical consequences can last because litigation can take years. A stay that keeps a rule in place while appeals move slowly effectively preserves the rule for a long time, sometimes long enough that the policy is functionally permanent. Can a lower court ignore a Supreme Court emergency order? You might think no, but the real answer is more complicated. Lower courts cannot directly overrule the Supreme Court. If the Supreme Court issues an emergency stay, district courts and courts of appeals must comply. Still, lower courts aren't powerless. They can interpret the Supreme Court's order narrowly and apply it only to specific parties or factual contexts when the order permits discretion. They continue to decide merits issues, build factual records, and craft reasoned opinions. If circumstances change, lower courts can issue new, fact-specific relief or ask for remands if the Supreme Court vacates a judgment. But the limitations are stark. A nationwide shadow docket order's practical effect is difficult to counter, which is why some legal scholars warn this tool shifts major policy choices into expedited channels, often bypassing the court's normal reasoned majority process. What can Congress do? Congress has the big hammer statute writing, funding control, and oversight, but it's blunt and slow. Congress can clarify statutes to close ambiguity, limit or protect agency authority, hold oversight hearings, subpoena officials, and use funding or procedural conditions to shape agency behavior. What Congress can't easily do is act quickly in a divided political environment or undo Supreme Court precedent without changing underlying law or amending the Constitution, which is practically impossible. So Congress is a long game solution while emergency orders operate in days or weeks. Scholars and former judges have floated several reforms aimed at increasing transparency and restoring doctrinal guardrails. Common ideas include requiring minimal reasoning, so even a short explanation of which Nken factors supported the stay would help lower courts, committing publicly to stricter adherence to Nken, requiring limited expedited briefing or a quick oral argument for high-impact applications, and increasing disclosure about votes or internal conference notes. Will reforms happen? Possibly, but there are political and institutional barriers.